Prosecutor Jeremy Saland now to the conversation. Jeremy, appreciate you joining us. Good morning. So tell us about this process for these attorneys obtaining a security clearance. How difficult is that? And I mean, is there a chance that, one of the attorneys could be denied a security clearance?
Well, in terms of the process, consider it like a big application. Where you went to school, any debt, any tax issues, have you ever been arrested, where you went to school, and then there'll be names given so that investigators can go and follow up and find out information about these attorneys. But on top of that, then once these investigators speak to these other witnesses, they're going to find other people to speak to beyond that which is provided by the attorneys. So it's a long, arduous process, not necessarily to fill out all the information, although it is a big job, but it's the follow-up and the work that the government has to do to make sure that these people can be cleared.
Are you getting a sense from the judge who will be presiding over this case, at least for now, Judge Eileen Cannon, and there is no sign or indication that she will recuse herself, as critics are calling for, but are you getting the sense that she's trying to move this case quickly along?
Well, this is certainly the right step, and there's no way to look at this and say it isn't the right step. This is something that needs to be done. I have a former colleague of mine who said it's kind of like telling these attorneys you have to wear a tie. You need the clearance. It has to happen. It has to move forward. So I think this is the right sign to show that she's taking it seriously. Now, if the judge wanted to delay the case, there's certainly many means by which she can do so. But let's look at this in good faith for now and say this is the correct step for the right type of case with highly confidential or top secret potential documents that don't want to be revealed to the public, or, as you noted just before in the segment, that are going to be released to the public by way of either Mr. Trump or any other co-defendant.
I mean, this is obviously a very high-stakes trial that will take place because, first of all, it's the first of its kind that we're dealing with top-secret documents. I mean, Trump is accused of, taking 31 documents illegally, some which have top secret designations. I mean, there's got to be some concern, at least from the U.S. intelligence community, about how these documents might be handled, right? Because some of them may be or will be shown to the jury. And of course, I'm sure there will be some redactions, but they're going to have to strike a balance with, redacting too much and at least showing, just how sensitive these documents were and the information that were in there.
Well, a couple of balances, if you want to call it that, have already been struck already. And what I mean by that is that the intelligence community, the Department of Justice, has said maybe not everything comes in. Some things may be too sensitive that we don't want to put these before a jury. So we're going to pick and choose out of all these documents which ones to present. And yes, certain things can be redacted, but you still need to provide the fact, the basis of the elements of the crime. You can't just say, this is confidential, or this is top secret, or this impacts the defense of the United States, and then not show it. So there's a rule, the silent witness rule, but what basically is going to happen in a coded type fashion, that information on those documents may not and very well won't be redacted, but it's not going to be necessarily displayed to the public. So that normally you may be putting it on a big screen and people can see, and it may say instead of a particular country, it may use a letter to correspond with that country or a person, so that this all can be protected and presented in a way that the jury understands, the defense understands, and obviously the judge as well.
Right, in a way that does not damage national security in any way. I am curious to hear from you, Jeremy, about the special counsel Jack Smith's approach. Glenn Thrush with the New York Times wrote quite an interesting analysis about his approach and described it as, an aggressive fast-track approach coupled with the conspicuously respectful posture toward the defendant. Part of that strategy, obviously, to avoid secondary fights or distractions. To that end, though, we saw Jack Smith not, pursuing a strict bond deal, not asking for a no contact order, no limits on travel. There was no cash bail, which is routine, for cases like this. Do you think Jack Smith's approach is the right one?
Absolutely. He is trying to really make this trial between the four corners of that indictment and the four corners of that courtroom. Why, for example, as you mentioned before, are we going to say, or when I say we, the government going to say the former president shouldn't be able to travel as the former president of the United States and as someone who's campaigning for office. That's going to create a sideshow that is just simply unnecessary. Why take those steps that are going to put obstacles in your own way to reach a conclusion? So certainly he has to be respectful. We can disagree or agree on what that actually means, but he also needs to just move this forward, get that discovery ready, and fight the fights that are willing and necessary to fight, and let those other battles go by.
Quickly, we got to go. Just one-word answer for me, if you don't mind. Walt Nauta, who's charged with conspiring with Trump to hide those classified documents. Do you believe that prosecutors are going to try to get him to, cooperate against Trump?
Possibly.
Jeremy Saland, thank you.
That's not the yes or no you wanted. I'm sure they'd like to.
Possibly. Good enough.
But it was one word.
It was one word, and he stuck with that. You're the best, Jeremy. Thanks.
That's what you said.
Still ahead.